All right, welcome everyone to our law and state statutes training with Jim Knapp. Jim is a mostly retired attorney with a career that includes 25 years in private practice, working with clients on all kinds of real estate transactions, 10 years as a state counsel and underwriter to 3 different national title insurance companies, and he was the interim director of property valuation and review for 2 years. He now spends his time presenting continuing education programs for attorneys, paralegals, notary publics, bankers, and others, as well as making custom pens and restoring English sports cars. So with that being said, Jim, I'll turn it over to you.
Okay. So start my timer here to remind me that I need to pay attention to the time. Oh, come on. All right. We'll start. We'll do the best we can to pay attention. So welcome, everybody. I guess we have about 25, 30 people, so that's a little bit too many people to pop open mics and ask questions. So feel free to put your questions, comments, or thoughts in the chat, and I will do my best to pay attention to the chat window and answer your questions as best I can. Bear in mind that I don't always know the answer to every question, and sometimes I might very well have to tell you that, gee, I should probably look up the answer to that before I try and answer the question, especially when we get into the more technical questions about exemptions and appeals and that sort of thing. So let me start with the classic. Jen mentioned I am a lawyer, and in fact, I am a lawyer, but I'm not your lawyer. So we're going to talk about cases. We're going to talk about legal principles. We're going to talk about a lot of things that sounds like legal advice. I want you to be careful because while I do my best to put the most current information in this program, I don't always get it right. And so before you decide to act on anything, particularly anything you hear in this program, you definitely want to consult with a legal professional that works for your municipality, because you won't win any friends and influence anyone by citing one of Jim Knapp's slides in a legal dispute without backing that up with the opinion of someone who is representing you specifically. All right, so over the course of the next 2 days, 2 sessions today, 2 sessions tomorrow, we are going to look at a bunch of topics. Specifically, we're going to look at the sources of the law. Where does the law come from? How is it developed? We'll talk about how to find the law. If you have a legal question, you could certainly start the research on your own, even though I recommend that you ultimately check with somebody who practices law before you take a position one way or the other on something that will make a difference to your municipality. We will take a look at some of the laws that are applicable to listing property, not all of them, and not in great detail, because I sincerely hope that by the time you finish this program with me, you'll be able to go find these laws on your own, and we'll give you some guidelines on how to read a statute and what to pay attention to in a statute. And so you will become, at some level, your own resource when the law comes around. When we talk about the common law, we'll talk about the court system and the application of what we refer to as common law or judge-made law, and how to find cases, and specifically how to read a case and understand what it actually stands for. Then tomorrow, we will take up 2 topics where we will use the skills that you learned today to look at a fairly narrow topic. And I think I've been doing this program about 10 years now. In the second year, I think it was Cy Bailey who mentioned, gee, it would be really good if you applied some of these general principles to a specific topic And I said, great, what would you like me to talk about? And he said, everybody always wants to know about exemptions. And I said to myself, great, a topic I don't know a whole lot about, but I guess I can learn. And so we will have one whole session tomorrow where we will talk about the law of exemptions, including statutes, applicable cases, and then we'll let you test your skills because I've got 2 1/2 questions that will let you analyze an exemption question and see how you feel like you did and whether you think I came up with the right answer, because neither of these is directly related to a specific case. I don't know that either of these questions has ever actually come up, but they bear a relationship to some cases that I know about, just to get me started. And then the 4th session tomorrow afternoon, we will talk about the appeals process, because even though you may start the appeals process as the person who set the original value that the taxpayer is unhappy about, you have a role throughout the tax appeal process. And it's important for you to understand how that role fits into the whole process. And although I won't tell you how to do an appeal, I will mention some things that did not work out well in appeals that have gone up through the court system. And so that will give you some ideas about how to think about an appeal as it comes about. So let's start at the beginning. Well, not at the absolute beginning, because the absolute beginning is the Constitution, and we're going to get there in a minute. But the first thing I put up here is something that you are all familiar with. Some of you have probably done this multiple times, particularly if you started being an assessor, stopped being an assessor, a lister, became a lister again, and so on. And that's the oath. And you might wonder, well, why is he putting that up there? And I already know what's in there. And that could very well be true. But about 25 years ago, at a Bar Association meeting, the then Chief Justice of the Supreme Court insisted that the 275 lawyers in the room stand up before they were served lunch. And only would get lunch if they stood up and did what he asked. Now, of course, this was the Chief Justice of the Supreme Court. We're all going to do what he asks. That's how the world works in our world. But what he wanted us to do was recite our oath again. We all thought, okay, that's interesting. This is sort of non-official. You only have to take the oath once to be admitted to the bar. And then he went on to explain that most of us had forgotten what that oath said. And it was really important for us to remember. And that really struck a nerve with me. So whenever I do one of these programs, and it's one that involves an oath on behalf of the folks who are listening, this is always the first key slide that I put up, which is remember what you promised to do. All right, so we're going to talk today in this first session about the statutes. And lawyers often refer to these as the green books. That'll become clearer later this afternoon when we talk about the brown books. And of course, unfortunately, not all the statutes are contained in green books anymore, but this is something that's held a tradition for many years. So I may accidentally refer to the green books. And if I do, what I'm telling you is the official publication of the Vermont statutes, because those are in green books. And if you go look in your town office, I suspect that somewhere you have a set of the Vermont statutes in the green books. They were published originally by Equity Publishing. And hopefully those books are up to date. And I'll tell you what that means in a minute. Because you may have occasion to go look in one of those books find something that we talked about. All right. So I promised to tell you about sources of the law. Well, here they are. The supreme law of the land in the United States is the federal Constitution. Following that, in terms of the significance of the law that is recited, is the Vermont Constitution, or if you live in another state, that state's constitution. Following up on that, we have the statutes that are passed by the federal legislatures, and then the federal legislature, and then the state legislatures. So the Constitution, at least by tradition in the United States, is a very broad statement of grand principles. But it's so broad and the principles are so grand, it can be really hard to apply them in ordinary life. And that said, they also don't address every possible contingency. So long ago, the drafters of the Constitution concluded that we're going to create a body of representatives who will get together periodically and adopt laws where they're going to take grand principles expressed in the Constitution and make them applicable to people's real lives. And we don't know what laws they're going to pass. We're going to give them the power to do that. And then we're going to trust that because these people take an oath and because they are intended to represent the people who are the ultimate source of the government's powers. Our government only operates because we agree that we're going to follow the principles expressed by the government. At least most of us. There are a few folks, sometimes known as sovereign citizens, who don't believe in any government and don't follow any principles of government law. Typically results in a lot of interactions with the law, which they don't believe in. And then after the legislature passes a law, and we're going to look at some laws, and maybe you'll come to the same conclusion that many of us who practice law do, which is they made a pretty good effort to explain what they wanted, but they weren't entirely clear. And besides, I don't know how that statute applies in my specific circumstances. So the people who drafted the constitutions decided that, yeah, well, the legislature is going to pass the laws, but we're going to create a court system whose job is going to be to look at those statutes and look at what's happened in the past and interpret those statutes as they apply in specific circumstances. And that's what we're going to do in the second session today. And then the third area, or the third branch of government, is the executive branch. So the President of the United States, the Governor of the state of Vermont, have certain statutory powers and constitutional powers to do stuff. And that most often relates to, in the executive sphere, taking a statute passed by Congress at the federal level or the legislature at the Vermont level and trying to implement it. So the legislature said to you, go forth and list properties. And to your tax collector, go forth and collect taxes. And to the court system, figure out if they're doing it right or not. And to the executive branch, there are going to be some holes in this process that we created. So what we're going to do is tell you, go out and create regulations. And these regulations are created by the agencies, departments, and commissions of the state of Vermont, in our case. And the idea is that they are going to look at the statutes and look at the cases that interpret those statutes. And they're going to give us guidance by adopting these regulations. And there is a very specific process about how regulations are adopted and how they become law. So I promised we'd go back and look at the Constitution, and I'm going to remind you again that you, as a sworn element of municipal government, are subject to this specific provision of the Constitution, which is that all officers of government, legislative, executive, are their trustees and servants, and at all times and in all legal ways accountable to them. Who's them? Them are the citizens of the state of Vermont. So bear in mind that your ultimate authority to do what you do doesn't come from your town government, doesn't come from the state government, it comes from the people. Now, the other fun one is I can't resist putting this up. And yes, the few times I've talked to folks in the legislature, when I've been called to testify, particularly on bills that involve the changes to taxes, like current changes to the transfer tax and a couple other things, I always manage to sneak this slide in, or in my written testimony, I always manage to slide this in, which is that all of us have a right to be protected in the enjoyment of life, liberty, and property. But in exchange, we have to contribute our proportion to that expense. But anybody who's responsible for passing a tax would be mindful of the fact that in the state constitution in Article 9, it says that the purpose for which the tax is to be raised ought to appear evident to the legislature to be of more service to the community than the money would be if not collected. No one has ever cited that as the basis for a decision they made in the legislature. I'm not sure anyone has ever listened to me when I said that, but my hope is that if I keep reminding people about this, and if we all keep that in mind, if you make it to the legislature someday, or if for no other reason than you're talking to your town government and the question comes up, well, should we increase the taxes to cover X? This is a really good question to keep in mind. All right. So I've talked enough, mentioned the legislature a whole bunch of times and statutes. And it occurred to me early on in my career of doing this particular program that not everyone has experienced the legislature and the process by which something becomes a law. Now, theoretically, this applies at the federal level, but I am most familiar with the operation of the Vermont legislature, having been involved in following various things through the legislature since about 2002, probably earlier, but as I started working for a title insurance company who was interested in some changes to the law, I spent a lot more time in the legislature listening to what was happening. And I can't recommend strongly enough that every citizen in the state of Vermont ought to go and attend legislative hearings and listen to the legislature, which you now don't even have to go to Montpelier. All you have to do is go on YouTube, because every committee, or almost all the committees, and the general sessions of the legislature are broadcast on YouTube. So you can sit in your office and you can listen to the laws being made, particularly if it's a law that affects you or interests you. So how is a law made? Well, all laws start with an idea. Somebody has an idea. Sometimes it's a legislator. Sometimes it's a committee of legislators. And sometimes it's one of us. It is perfectly within your power as a citizen of the state of Vermont or the United States to contact your legislator. And all you have to do is go to the legislative website if you don't happen to know who represents your district. And you can look up your district and you can find out who represents you, and you can reach out to them by email, by telephone, by running them into them at the store. And you can say, you know, I don't think there's a law about X, and I think there ought to be. And in fact, I think it ought to say this. Now, some legislators will go, Some of them will take your idea seriously and they'll go to the next step. They'll take your idea and they'll go to a group of lawyers who work for the legislator in what we call the legislative counsel's office, or better known as leg counsel. And they'll say, hey, is there a law about X? And leg counsel, who I believe knows everything in the world about Vermont law, will say, no, there's not. And the legislator will say, well, I want to introduce one in the next session. And leg counsel will go, okay, we'll draft it. And that's what they do. They sit down and they are specialists in the creation of the language that goes into a statute. And they will think about what the statute ought to say, and they will write it down. And they'll go back and they'll tell the legislator, okay, we wrote it, here you go. And so the legislator will go to their the House or the Senate, depending on which they sit in, and they will say, I want to introduce this bill. And somebody and the chair goes, okay. And at some point in a legislative session, the chair will say, we're introducing this bill, and it's going to be read for the first time. And after it's read for the first time, almost all the bills that have a significant effect on creating new statutes or amending existing statutes that actually have a legal effect will be assigned to one of the 15, 18 committees in the House and 12 committees in the Senate. And that committee will take up the bill, and it's a subgroup of the legislators, and they sit in a little room in the Capitol building, and they'll talk about the bill, and they'll invite people in to talk about the bill. And you may think that only lobbyists and lawyers like me or government officials get to talk about the bill, but that's not true. If you know something about a bill that is winding its way through the legislature and you want to be heard, you can reach out to the committee and say, you know, I know something about this and I want to be heard. And I can give you a perfectly good example. 2019, when we decided to, or 2018, when we decided to undo the lease lands, the bill that started the process of removing lease lands from the statutes and converting them to fee titles was actually started by a couple who contacted their legislator in Underhill and told their legislator what a horrible experience they had on account of these things called lease lands that nobody even knew existed except for about 20 lawyers in the state of Vermont, and probably all the listers who had to deal with it. So those folks went to the legislature and they told the legislature what a terrible thing that was done to them. And the legislature agreed. And that's how that law came about. So once the first committee finishes the bill, they may decide that another committee needs to look at the bill. And often if the bill involves money, there will be a committee who looks at it, and then it will go to a different committee whose specialty is money. In the Senate, that's Senate Finance and the Appropriations. In the House, it's Ways and Means. And the idea there is that those money committees who are responsible for creating the budgets and then for figuring out where the money's coming from will address the money questions. The bill then goes back to the body that originally introduced it. There's a second hearing, and there's a second reading and a third reading, and then they vote on it. And if the House votes to pass a bill or the Senate votes to pass a bill, well, we're not done, because now it goes to the other. So if the House passes a bill, it goes to the Senate. If the Senate passes a bill, it goes to the House. And we repeat. Steps 4, 5, 6, 7, and 8. It's assigned to committees. There are committee hearings. People think about it. It goes back to the floor and it passes. And this may come as a surprise to you, but if the House passes a bill, the Senate often changes it. And so it has to go back to the House, because the Senate can't just unilaterally change a bill that the House passed, and the House can't unilaterally change a bill that the Senate passed. They all have to agree. So maybe the amendments go back to the original body, After the second one hears it and everybody says, yeah, that's pretty good. Let's pass this. And so it passes. Often what happens is the House and the Senate stare at each other in the hallway and they say, those amendments weren't very good and we're not going to pass them. So at that point, the bill or the two versions of the bill are assigned to a conference committee, which is typically two or three legislators from the House, 2 or 3 legislators from the Senate. They lock themselves in a room and they hash out a bill. And if they get something that those 6 can live with, it goes back to the floor of the House and back to the floor of the Senate. And if everybody agrees that the conferred upon bill is a good one, it passes. All bills ultimately go to the governor, who has to sign them. The governor can sign a bill and approve it. The governor can veto a bill which says what you people were thinking, but this is a terrible idea. And in fact, if you followed the news in this session had more vetoes than all of the last, 25, 30, 40 years combined. I think there were 8 vetoes in this session. I believe 6 of them were overridden by the legislature, and 2 of them did not meet the standard to be overridden. And the third option is the governor can let a bill become law without signing it by following a certain process, which the governor may do if he personally doesn't like the bill, but he realizes that enough people did in fact like the bill that maybe we ought to let it go. So real quick, I'm not going to go through this in any great detail. This was the activity on a bill that was designated originally as H480, and it was adopted through the legislature, signed by the governor, and it became Act 68. And I'm not going to go into great detail. You may have already heard about Act 68 because it directly will impact what you do someday. And it is an act relating to property valuation and reappraisals, and there's a whole bunch of stuff in there. And if you've not read Act 68, then I will show you how to find it, and you might want to go take a look at it. So you'll notice that the history here starts on 3/21/2023. That's pretty late in the session. The session started in January. Why is this bill starting so late? Well, the answer is the bill is starting late because this is what was called a committee bill. And House Ways and Means was the group of people who came up with the idea, and it ground through House Ways and Means for a long time on step 1 and step 2. And finally, it got introduced in March. And then you can see it sort of blew through pretty quickly. It touched on House appropriations, went back to Ways and Means briefly, passed through House appropriations. You can see here it passed the House of Representatives and was moved to the Senate. It went to the Senate Government Operations, better known as GovOps. It touched on finance. It went to the Senate Appropriations Committee. It went through several iterations in finance and appropriations, ultimately gets reported back to the Senate, where it passes the Senate, goes back to the House because the Senate, of course, changed it. And in this case, the House and Senate concurred in the amendments. The bill was given to the governor, who signed it, and it became law on June 14th, 2023. So I will show you in a moment where that history can be found. And so you can look at any bill you want to look at. And as I promised, here we go. Let's get started. The legislature publishes a website that is fairly usable. The benefit is it's free, which it ought to be since our taxes paid for it. And it is at legislature.vermont.gov. In my mind, this is a great way to quickly find a statute if you kind of know where you're looking. It has a search tool, kind of like a Google search, but not nearly as good, that only operates on the legislature's website. And I'm going to go through some slides, and I'm actually going to show you how that works in just a minute. The other source, which is a more official source than the legislature, is the so-called LexisNexis website. You can get there from the Vermont legislature's website. And the LexisNexis source is where the published books come from. So LexisNexis is, in theory, the official custodian of the published Vermont statutes. That said, the legislature's own resource is good, but it's not technically the official site. If there was a glitch and something got published to the legislature's website, but the official publication went to LexisNexis, then this is ultimately the source that you would want to look at. And it may be easier, frankly, you'll see why in a couple of minutes, to just look at the books. So, some other ways to quickly find statutes, because it may not be your thing to pop open the legislative website and drill your way down through a bunch of menus and choices and links and that sort of stuff and find what you're looking for. It may not be that easy if you kind of know what you're looking for, but you're not exactly sure where it is. So, where else are you going to find it? Well, you might find it in another published work, your lister's handbook, stuff that the league puts out. There are, later today, we'll talk about cases that will cite statutes. So you might find a case, you might wonder what the statute said that the case was based on, because your facts aren't the same as the case. And so you need to sort of go back a couple steps to the more general principle and figure out what the general principle is. So you might find it there. You can try and Google. You could Google something like Vermont statute church exemption. There's a pretty good chance that somewhere in those Google results, it's going to point you to the correct statutory citation. The question is how much other stuff you have to wade through to find that. So I'm not a big fan of flat out Googling the principle to sort of get started on it. And of course, I can hear you all saying in your mind, well, of course not, Jim. This is what you do for a living. You have all kinds of resources you can use. And that's true. But sometimes some of those resources don't work all that well. And sometimes you got to start with Google. The other option is Green Books. Go find your Vermont statutes annotated in your town office, or some libraries have copies of the Vermont statutes. You can go to the Vermont Law School in South Royalton. I don't know if they have Green Books anymore. They probably will sit you down at a Westlaw terminal and try to explain to you how to use it. But there are two things you need to know about the Green Books. There is an index. Historically, it was never very good. I don't know much about indexing books. I know it's hard. I know it is a highly skilled profession. My wife wrote a book many years ago, not one you'll find on the bestseller list. It was a pocket manual for neonatal intensive care nurses. And it's out of publication now. And after they finished writing the book, they were told they had to create an index. After about 20 minutes of trying to do that, they called up the publisher and said, how do we do that? And the publisher said, you pay this person $350. This was in 1983 or 1984. So that was no small sum of money. and they do the index in the book for you. And that was the best money that my wife ever spent on that particular project. So indexing is hard, but the Green Book index isn't very good, even probably because it is hard. The other thing that you need to pay attention to is in the back of the Green Book. So you open them up, and the last cover, the back cover, should have a bunch of pages that are stapled together and stuck in a slot in that back cover. And that's the pocket part. And that's because Equity doesn't publish the Green Books every year. In fact, sometimes they'll go 10 or 20 years between publishing the actual Green Books. And instead, what they'll do is they'll put all the changed laws in these stapled pages that are stuck in the back of the book. So you may go into the book and you find exactly what you want, and you're ecstatic because this all worked. And then you go look in the pocket part and find out that the statute that you were about to rely on to do something was repealed. Darn. But that's why it's important to look in the pocket part, because the statute you found in the hardcover Green Book may have changed over time. We're going to talk about that in a minute. And you need to know what the most current version of that statute is. All right, the last resource is one you may never have thought about, but I'm going to tell you that a great resource is a law student that you happen to know, a lawyer that practices in town, or maybe a lawyer that you don't even know all that well. In my experience, and I have a fair amount, about 44 years, going on 44 years now in November. Most lawyers are generally happy to share what they know with folks who need an answer, as long as you don't abuse the circumstances. Now, since I've retired, I answer questions for everybody. It's mostly lawyers that I knew in practice, but I'm going to let you in on a secret. Several of your colleagues have called me after they took this program and said, "Hey, Jim, we're having a little trouble getting started here. Can you help us get started on figuring out what this is or what this means?" And the answer generally is, if I'm not doing something else, I'm more than happy to help. So that last resource, the friendly lawyer or friendly law student, will turn out to be a good resource for you to get you started. Don't count on a lawyer putting in hours and hours of research to answer your question for you, unless you're paying the lawyer or they happen to work for your municipality. All right, so as promised, here's the front page of the legislature's website. You go to legislature.vermont.gov, and you're going to get a picture that looks like this, unless you happen to do that on your phone, in which case the picture looks different, but all the resources are there. Remember, on your phone up here in the corner, there's going to be a bunch of little, I think it's 3 little bars. And if you click on those 3 little bars, you'll get the choices. All right. So if you want to know about a bill that isn't a law yet, you go to Bills and Resolutions. If you want to listen to a committee hearing, you go to the committee. But for the purposes of this program, you're going to click on this button, which is Vermont Law. And you're going to get this. And so you're going to have the choices of going to the Vermont statutes online. You will have the choice of running a search on the statutes. And you will have a choice of going to the LexisNexis website. And I'll show you a screen there in just a minute. If you want to know what the laws that happen in this session are, you're going to go to the Acts and Resolves. But if you are looking for something super specific, like, I heard they changed the law on exemptions last session. I wonder if that makes a difference to what I'm going to do. Well, you can jump to this link right here, Acts Affecting the Vermont Statutes Annotated Sections. And someone in Ledge Counsel's office has done a great job for you, because anytime a statute was changed, they keep a record of it. And they keep a record of the bill number and the act number that made that change, and then they publish it. So if you know you are interested in section 380211 for some reason, and you heard that something changed in that bill, you can go to this link and it will show you relatively quickly, not real quickly, but relatively quickly, where to go look to find that change on your own. All right, so, oops, back here. I'm going to click on this link right here. Not really, I took a screenshot. And then I grabbed out of the middle of the page that you get a couple of things and I highlighted them. So my guess is that most of you, if you are interested in the law that affects what you do as listers, are going to be interested in Title 24, because that's the area where the statutes are collected that relate to municipal and county governments. Title 27, which is where those few statutes that address property law are found in Title 27. 27A, which is where the Uniform Common Interest Ownership Act is. That's where the law that regulates condominiums and planned communities is found. And we'll talk about that in a case down the road, either this afternoon or tomorrow afternoon. And then the last one, which is probably the big one for you, which is Title 32, which is where the taxation and finance statutes are collected. Now, let's say I clicked on this link and I get a page that looks kind of like this, except it actually starts with chapter 1. But I decided to jump down here because this is a pretty good block of statutes that are going to affect what you do. Chapter 123, how, where, and to whom property is taxed. This is the current use statute. These are the dreaded exemptions that we'll take up in the first session tomorrow afternoon. This is misnomered as the quadrennial appraisal of real estate, because for those of you who have been serving long enough, it used to be every 4 years you had to do a new reappraisal. That has all changed, of course, in the modern world, where you do reappraisals when your statistical elements fall out of the bounds. Chapter 129 tells you what to put in your grand list, and Chapter 131 regulates appeals. So as you can see, the statutes are organized by subject, by subtopic under the subject, and then this is what the legislature's website looks like. This is what LexisNexis looks like. Now, remember I mentioned that the legislature's search button isn't particularly good. It's not bad, it's just not as good as Google. On the other hand, this one, the LexisNexis search button, is actually really good. These people know how to do search. What they don't know how to do is organize things very well. So if you get to this page and you're a little confused, what you're going to do is click on this plus sign down here in the corner. And this plus sign is going to open up a series of cascading menus until you get to the menu that has the specific statutory sections that you may want to click on. I find this is much easier if I have a sense of where to go. I occasionally use this service if I have no idea where to go to get started. But as you probably guessed, lawyers have other resources, including legal specific research sources. That is where I really go to do my research if it's for someone who needs to know the most current law right now. All right, so search works like Google. I know all of you have done a Google search, and I know all of you have put in some words that you thought were really good words, and you've gotten results that surprised you because words have lots and lots of meanings. And you may be thinking in terms of a set of words, but they're not the words that other people used. The good news is that Google's search engine is a very, very sophisticated algorithm that knows how to take the words that you used, and sometimes it says, all these words that they use together aren't really what they meant. I'm going to guess, wild guess, this is what you were looking for. And sometimes that works pretty good. The problem is that when you use the Vermont Statutes search engine, and even the LexisNexis search engine, one of the issues is you have to pick the words that the legislature used when they wrote the law. So I can't think of a really good example off the top of my head. I was probably supposed to do this, but I'm going to go back to something that we all know. There is the color blue. There is the color aqua. There is the color cerulean. And there are about 800 other words that describe blue. If the legislature didn't use the word blue in the statute you were looking for, but did use the word aqua, if you type blue into a search engine, you may never find what you're looking for. So part of your research skill in going and looking for any of this stuff is thinking about all the words that the legislature might have used in the context of the subject you're looking at. So you want to be careful if you use a highly specific word. You might not use that one either. So maybe you have to make the topic a little broader. Maybe you use, if you type tax into the legislature's search engine, you are going to be overwhelmed with responses. If you type the words tax and value, you're still going to get a lot of results, but we're getting closer. And so the idea is, as you run the search, it's always best to start with a broader word than a narrow word, because if you start with a narrow word and narrow it down from there, you may never see the result you're looking for. So start a little bit broad and work your way towards the narrower. The key is reading what you find and see what kinds of words they used. Maybe you get close. You know there's a statute on a specific topic. Churches, okay? You're going to find a fair number of stuff on churches, and you're probably going to find what you're looking for. But in a few cases, they use the word pious. Okay, pious sort of relates to church in a grammatical, theoretical, theological sense. If the statute you were actually looking for is the one that uses the words pious rather than church, and you use the word church, you're going to find it. Technically, you actually will, because the word church appears later in the statute you'd likely be looking for. But that's kind of an example of how it works. And that's why you want to look for synonyms. And then the real key is assess your results. If you're not getting what you want, go way back up to the broader hook and start with a different starting phrase and work your way down again. All right. So in the process of doing research, or more likely in the process of reading some of the materials that I suggested, specifically your Lister handbook, materials put out by the league, even case law, most of them are not going to write the actual statute. They're going to say something like, churches may be exempt from property tax. They could say churches are exempt from property tax, but that could be confusing, as we're going to find out tomorrow. But what they will do is they will give you what's called a statutory citation. Now, I'm going to talk to you about this for 2 or 3 minutes. If you decided to go to law school, you would have about 6 weeks of a course in your first year, where you would learn so much more about citations than you ever wanted to know, including the proper placement of commas, apostrophes, semicolons, and all kinds of things that literally make no difference to your ability to practice law, but you don't pass the course unless you know where they all exist. So I'm going to give you the short version. And for statute, what you're going to look at is you're going to see something like this piece that's in bold right here. And so let's go piece by piece through what this means. The 32 means the title. Now remember back here, we said stuff is organized in topics and then subtopics. And so title 32 in this case is somewhere in the taxation chapter. All right. So then the VSA here, or sometimes V period, S period, A period, which I believe, although I'm reaching back in mind, is the correct way to cite this. Nobody puts the periods in real world. Everybody just uses VSA. Stands for the Vermont Statutes Annotated. Wait a minute. What does the annotated mean? Well, in order to help you out, Equity, who was the original publisher of the Vermont Statutes, and then LexisNexis, who bought Equity, do a lot of helpful stuff. Following the statute itself, they put in a bunch of notes, which we refer to as annotations, but they'll tell you if the statute was cited in a case. They may put in notes that the people who, when the statute was passed, included notes that weren't necessarily a part of the statute, but they might have included some notes to help you understand what they thought they were doing when they passed the statute. And so in an annotated version of the Vermont statutes, you will get those notes, you will get the statute itself, you'll get reference to cases, and you'll get the all-important statutory history. All right. Then if you're looking for a federal statute passed by Congress, the United States Congress, you're not going to look in the Vermont statutes annotated, you're going to look in the US Code for U period, S period, C period. And you may see it cited as USCA, and the A just stands for the annotated version. Oops. All right. So this little symbol here just means section. But rather than write out the word section, hundreds of years ago, somebody concluded that, well, this is not a letter in any alphabet that we typically use. That would be, unfortunately, sort of a European-centric issue. We're going to use this to stand for the word section. So whenever you see this, it just means section. And then, okay, we get the 3802. That's the section, because it's preceded by the section symbol. The 11 is the subsection. The A is the subsection. The A, or the two little I's, or one little I in the citation, boy, did I make a mistake there, stands for the subsection, and often designates a list within the subsection. So to find this, you would go pull out the green book that starts with 32. There are actually two of them, so be careful. This would probably be in the first one if I remember correctly. You're going to turn to the page that has this section on it. Nowhere does this use a page number. Nowhere in this citation is there a page number. It is all about the section. Then you're going to follow down to subsection 11. You're going to look under 11 for a subsection A. And then under that, you're going to look for the subsection of the one little I. And that will probably be way too detailed for the question you're actually looking for. So now you go back and you start reading the whole of 380211 and hopefully find what you're looking for. All right. So that's how you find a statute that's in the books. Well, the legislative session just finished in June, right? That's when the veto override session was. So there's a whole bunch of stuff out there that hasn't made it into any of the books yet because the publishers are just barely finding out what the laws are. And then they gotta set them all up and print the pages and bind the pages and send you the pages. And so what happens if you want to find a law that just passed? Well, the answer is you go back to our legislature.vermont.gov and you go to this section that's called the Acts. And you go to this tab, which is the Acts and Resolves of the legislature. And once you click on that, you will be sent to a page that looks like this. Key element here. You only get to see the Acts and Resolves from one session at a time. So look in this corner and be sure that this bar right here is telling you what session you're looking in. If you wanted to find an act, the actual words of the act from a bill from 2021, you're going to pull down this little button right here and pick 2021 to 2022 off the list. This list here will change and it will show you the acts from that session. Again, be careful because sometimes there's a special session. And so there may be a special session in 2021. There may be a special session in 2022, 2023. And if you accidentally pick this one and look, there's not going to be much in that list. So just be sure you're looking at the right set of session dates. And then if there's a special session, you may have to look there to find your statute if it was one of those statutes that got vetoed and then the veto was overridden. And then remember I said this is a great way to find something because you remember there was a newspaper article that said, hey, the legislature changed the transfer tax. And if you're like me, not only did you not see the article, but you didn't hear about it until someone called you up and asked you an extremely detailed question and your response was not the confidence ensuring, oh, sure, that was in act number, it was, what are you talking about? So we did go back and find it, and I was able to answer their question, but I totally missed the change in the law. If you click on this link, well, where you end up is right here. And you remember I mentioned that there was an act relating to property valuation and reappraisals, and that was act number 480. Well, that changed 32 VSA 3436. I don't actually know what that is, but if that happened to be what you were looking for, it would tell you to go find Act 68 in the 2023 legislative session and look in section 6. And you can see that along here for everything else, there are various things. Interesting note, in every session, there is an act relating to technical corrections. And there is often an act relating to miscellaneous corrections. And then there's a fun act, which is called the act relating to miscellaneous changes in the judicial statutes. So sometimes a bunch of good but little ideas that don't deserve their own statute get mushed together in something like one of these technical corrections or miscellaneous change provisions. All right. I also mentioned that there is something called a legislative history, because as you know, over time, statutes change. Now, for your purposes, you inhabit an interesting time block in the law, because pretty much the day you care about is April 1. Not because people are going to play jokes on you tonight, but that's not the real issue. That's your date for valuation. So what you really care about is what was the law on April 1. Because if the law changed before April 1, then it would be the law on April 1. If the law changed after April 1, it most likely would not affect you for that year, unless, but, except, yes, lawyers are annoying because we will tell you something and then the next thing we will say is either except, but, or unless. And so since I am what I am, there are some laws that are passed that are actually retroactive. It is not normal for a statute to operate retroactively because, of course, it can have some significant effects. You do something expecting that the law is X on the day you do it. The legislature 5 months later passes a law that says, well, that wasn't the law. The law was X minus Y and Z, and what you did is now illegal. Well, that's not fair. You followed the law as it was on the day you did it. That should stand for something. Now, the fact of the matter is that most of those retroactive laws don't take away money. They don't take away your property. They can sometimes subject you to criminal proceedings, but not very frequently. The big one this year was there was apparently a change in the way fees are added to fines. And although I didn't follow the whole thing, there was some retroactivity to the way fees are collected for fines. And it was a big brouhaha in the legislature. So that may be a relevant change. If you happen to do something wrong and you're in the process of being prosecuted for it, instead of a $27 fee attached to your fine, it might have gone up to $35 or something like that. So, but in many areas, particularly if you practice law, you want to know when the change took effect. Let's say, for example, you want to put up a fence and you need a zoning permit to put up a fence. And the zoning law, which is not passed by statute, but it is passed under a statute, changed. And you're about to buy the house and the house has a fence and you look at the zoning law and it says in the R4 district, south of Heinsberg Road, houses can't have fences that are over 4 feet tall. And your fence is 6 feet tall. Well, is your fence illegal? Probably not, as long as it was built before the zoning law changed. Same thing applies in the legislature. And so the Leg Council and the legislature keeps track of when the law changes. So here's an example. You may have noticed that they really like this law. If you look, for a while, they were changing it practically every year, certainly every couple of years. And they would add things and they would subtract things. And in fact, the most recent change to this law, at least when I looked up the legislative history, which could have been for last year's program, was a change in 2021. And that change in 2021, oh, look, the statute I was telling you about is section 3802, which is the primary statute on exemptions. Well, this told me where to go look. In the 2021 session at number 71, section 12. And I looked that up. And on the legislative website, and I followed the act number all the way through. And I found out that the change was they added a new exemption for real and personal property owned by a Native American tribe that has been recognized pursuant to 1 VSA Chapter 23. There's your statute. You would go to Title I, Vermont Statutes Annotated, and look in Chapter 23. Or owned by a nonprofit organization organized for tribe benefit, provided the property is used for the purposes of the tribe and is not leased or rented for profits. And that exemption took effect on July 1, 2022. So if you did your 2023 grand list and you had one of these properties, you should have listed it as exempt. All right. We still have some time. So part 2 here. Once you find a statute, what do? You read it. And when you read a statute, you have to have a special skill that lawyers learn in the first year of law school. And quite frankly, having made it through law school, if they stopped law school after the first year, most of us would have gotten along just fine because we learned everything we needed to know. Not entirely true, but we learned the skills that we would use to learn everything else we needed to know in the first 3 months of law school. So, what was it that we learned? The first principle we learned is most words in a statute are going to have their ordinary meaning. That means you can look in a dictionary. It doesn't have to be a legal dictionary. And if there's a word in the statute that you're unsure of what it means, well, look up the definition. But what you have to be really careful about is that sometimes the legislature takes words that have a meaning and they change it. Not to be unfair, not to be unreasonable, but because they want the word to mean something more or something less. And to do that, they write the word in the statute and then they give it the meaning they want. So by way of example, if you were to look up Title 32, right here, Chapter 121, Section 3481, you will see that this statute starts with the key words that you want to pay attention to. The following definition shall apply in this part and in Chapter 101 of this title pertaining to the listing of property for taxation. That's you folks. Subsection or Section 1, subsection A, appraisal value shall mean, and this is not what it means. This is the summary of what I grabbed in there. So there's a special definition for property that's in the use value program. There's a special definition for property that is subject to a housing covenant. And there is a special definition for what constitutes a renewable energy plant and how you should treat that for listing purposes. Okay, so I said words have their ordinary meaning, right? Well, except, but, unless. It's a word that's defined in Title 1 of the Vermont Statutes Annotated in Chapter 3. And there are about 100 words in that chapter that have meanings that apply in the Vermont statute. They may be close to their ordinary meanings, but they are not necessarily their ordinary meanings. And there is one in there that is a little unusual. I happen to know about this one because it was the source of great angst in the legal profession for many years, and that is the word person. You all know what a person means. Now, persons for statutory purposes are not just individuals, but they are things like corporations, limited liability companies, and other things that are not just human people, but have the status of being a person. The reason I raise this is one of those things is one of the things that is not in there is a trust. And so most trusts, unless they're organized in a state other than Vermont, are not technically a person. And that created a huge problem in the legal profession for many years until the legislature fixed it. So what you're going to do is when you're looking at a statute, you're going to think about whether there's a word in there that is used to connote a broader concept than you may think applies. And what you need to be careful about is that sometimes the definitions are hidden away, but more likely what's going to happen is a specific statutory section is going to refer to another statutory section. So for example, in the property transfer tax statute, they use the word principal residence. You all know what a principal residence is. or do you? Because there is a provision in there that says the term principal residence means the same as the term defined in 32 VSA section 10,002A. A? Well, we know A is a subsection, not in this case. A is its own standalone section. And in 10,002A, there's a very specific definition of a principal residence, which interestingly can theoretically include a lot that has no improvements on it. Because under the land gains tax statute, which is what you find in 10,000, and under the property transfer tax statute, because it's incorporated by reference, a principal residence can include a bare piece of land on which the purchaser builds a house within 2 years and occupies it as their domicile. So, special definitions. It's okay to start with the concept that the words have their typical meanings, but if the application of this statute in your case is going to have a consequence, someone is going to be taxed too much, not taxed at all, the town is going to pursue a lawsuit that somebody's going to find out had no basis whatsoever, which means you're going to spend a ton in legal fees. It's always good to check the words and see if there are any special definitions. The best way to do that is to call somebody who practices law. All right. So the courts, yeah, I know that's session after this one, but the courts have told us that when you're reading a statute, you should keep two goals in mind. The first are defined words are always used consistently throughout a statute. If the statute uses the word person in 14 different places in the statute, the word person means the same thing in every single one of those places. Unless for some reason in some subsection somewhere, there's a added clause that says person, comma, for the purposes of this specific subsection includes chickens. Well, okay, if you're looking at that specific little section, then chickens are persons for the purpose of that statute. But generally, if the legislature uses a word in a statute and uses it in multiple places, they are believed to mean the same meaning throughout. And again, if not, then the common meaning applies. All right, so a couple of things. Is statutory interpretation for judges and lawyers only? No. All of us interpret statutes throughout our entire lives. We may not know we're doing it, but we know it's not legal to go through a stop sign without stopping. So you're doing an interpretation of a statute when you come to an almost stop, when you kind of hesitate, but you don't actually stop, when the car makes the little bounce that says that the brake's fully engaged and the car has lost all its momentum. On the other hand, blowing through the stop sign at 35 miles an hour didn't take much interpretation, and your interpretation is wrong. I've mentioned this a number of times. I'm going to mention it one more before we move on. Be cautious if there are adverse consequences. Check with someone. Follow your plain meaning unless there are definitions. And this is my favorite one of all. The courts constantly tell us when you're interpreting a statute, resist creating an absurd result. I am not going to be cynical and say, and then the court goes on to create an absurd result. But that has happened once or twice. This is the other key part. Not only should you resist creating an absurd result, but you have to be careful to be sure that you apply all the parts. When we talked about a statute that has a bunch of sections under the main topic, well, maybe the main topic tells you exactly what you want. And you read down to a subsection and it says, well, yeah, but this main topic doesn't apply in this specific circumstance. You don't like that answer. It's not the one you wanted. So you go back and you say, well, the general rule applies. No, it doesn't, because you didn't give effect to the whole statute. You read the statute, but you didn't read the excepts, buts, and unlesses. And if one of those tosses out your desired result, well, too bad. You can only use the statute if you follow the whole statute and apply all of it consistently. All right. So I am not going to read you all of the statutes that relate to your job. I told you how to find them. I'm happy to help you find them if you are looking for something and you can't find what you're looking for. Like I said, as are most lawyers that I know, and law students just love to show you how smart they are. So if you can find somebody who's in their second year and you want to ask them a question, they're not supposed to give you legal advice, but they can certainly help you work through a research question with great skill. All right, so starting in chapter 121, here are the general topics that are included in that section. Creating property valuation and review. What are its obligations, its duties, and most importantly, what are its powers? This is an interesting one, section 3411(3. Authorizes property valuation and review to adopt rules. And you know they do, because you know that PVR has some rules. I think I heard a rumor that they were working on some revisions. I think somebody told me that. And so what's a rule? I haven't mentioned rules throughout this whole thing except the very beginning. And you remember I said that the executive branch, so the governor's office and everybody who operates under the governor's office, which includes the tax department, which includes property valuation and review, has the power to adopt rules. And rules have the force of law. They don't have to go to the legislature. The courts don't create them. The executive branch creates them, and they are just as good as a statute. But the process is a little bit different. So the process for creating a rule involves this. The legislature may direct, let's say in this case, PVR to adopt some rules. Okay, now we've got some guidelines, and this is what the rules are supposed to be. But most often, what happens is the executive branch discovers that the legislature passed a statute, hasn't been interpreted by the courts yet, and it's just not clear. This happened a lot in transfer tax, land gains tax, and lots of other areas in the tax law where there's a broad statute that says do X. And the problem is what they meant was X1, X2, X3, X4, X5, X6. They just said X. So the tax department starts the process, and the people, the so-called subject matter experts in the department and the lawyers who work for the department will sit down and they will say, so what does this statute mean? Let's write some words. And they write down some words, and everybody looks at them and says, well, some of these words aren't very good. Let's throw out these words. And then they get to a set of words that they really like. They can't just adopt it. First step is to send their proposed rules. I can't actually remember the sequence. I think they file the rules with ICAR, which is the Interagency Committee on Administrative Rules, and it's made up of a bunch of people who are designated by their departments. And the idea is that ICAR will look at the rule and say, well, you can't do that. That's inconsistent with this law, which we manage. Oh, okay. Well, what should the regulations say if we want to be consistent with your law, but we want this to be the result? So they'll work out some issues like that. It's specifically meant to help all the agencies get on the same page. So if you think about current use, well, tax technically sort of manages current use, but agriculture has a lot to say about what's in the current use regulations, particularly as it relates to farming. And forest parks has a lot to say about what's involved in forestry. So they may very well show up in ICAR and say to tax, you can't do that. because that's going to screw up something that we're doing somewhere else. Okay, we'll fix it. Once you've got a set of regulations that are ready to go, they go out to the public for comment. Now, they don't fly a big sign from the top of the agency building saying, we have some new rules, go look. But they do publish a notice. And if you work in specific areas where knowing that regulations are coming out, you're probably going to hear about them because you may even have been consulted about the regulations before they adopt them. Or you might not. Sort of goes both ways. But you likely will find out. So you would have somewhere between 30 and 60 days to provide public comments on your rules. And then the rules have to be adjusted. The agency has to look at all the comments, and they are generally considered obligated to take into account the proposed comments that have some real meaning. It's not going to help if you send the tax department, this is a stupid rule. That they will read it and they will put it in the round file on the floor under the desk. They will read it. If, on the other hand, you tell them, if you use this word in this context, you are going to affect not only what you appear to be trying to do, but these other three things, they're going to be more careful about the words they use. All right. So once you've got your set of rules and you take into account all your public comments, the last step before you can adopt the rules is to go to LCAR, Legislative Committee on Administrative Rules. And in theory, the legislators on that committee get to look at your rules and look at the statute and say, yes, that's exactly what we wanted you to do. That's exactly what we meant by that statute. And you win. The final step is you send your rules to the Secretary of State, who publishes them in the compendium of official rules of the administrative branch of the state of Vermont, and it is now law. So that's why it's important to figure out if there is a rule. So you may have to look at statutes, you may have to look at cases, and you may actually have to look at administrative rules before you can figure out what the actual consequence of what you're about to do is. 3431 we mentioned was the Lister Oath. 3432 was one of my favorite statutory sections, at least for the 2 years or so that I was the interim director at Property Valuation and Review, because it said that listers and town officials have to render such assistance to the director as the director may request. Most directors are pretty good about not bothering you too much. Once in a while, we are going to come, or they are going to come and ask you about something, and there is actually a statutory basis for them to do that. 3436 is the assessment education, or why you're here today. Actually, you're here today because you heard this is a wonderfully entertaining program. At least I hope that's what people are saying. Not it's a terrible program, but you have to sit through it to get your your Lister 1 certification. All right, some key definitions, places, things that you should look for. 3481 that we talked about, which was appraisal value. And don't worry, we're going to talk about covenant restricted housing and that sort of stuff. 3484 has always been one of my favorite statutes. It certainly hasn't applied in the last, I don't know, 100 years or so. But when people used to live in hotels and boarding houses instead of apartments, apparently there was an actual provision that said that the owner of a hotel, boarding houses, and dwellings had to provide the names of residents to listers and the names of the persons that they employed. Why? Because 100 years ago, your job included getting an inventory from everybody in town of their personal property because it was going to be taxed. And if they didn't own a house, how did you find out that I was living in a boarding house? Well, the answer is because the owner told you. So there's some great old statutes like this throughout all of the Vermont statutes. And when you run across one, it's a gem. 3485, I've heard tell that in a few towns, periodically, you have some trouble getting the clerk to cough up the transfer tax returns to help you do your job. Well, there's actually a statute that applies, 32 VSA 3485. All right, real quick. in chapter 123, I decided to snag a section out of the index to the statutes because there's great stuff in here, you know, the how, where, and to whom property is taxed. So there's stuff like manufacturing machinery, construction equipment, water rights, orchards, barns, silos, and other farm structures, buildings on leased land. This one actually comes up fairly regularly. That's a statute you might want to keep in the back of your mind if you have buildings that are built on land for long-term leases. Assessments against the state easements and flood control projects, and timeshare projects. This is another one for some of you in the resort communities. You might want to be aware of what 3619 says about how you should assess timeshare projects. We're also going to talk about a case either this afternoon or tomorrow about assessing timeshare projects. All right. Oh, hey, look, here you go. 3608, buildings on leased land or land not owned by the owner of the buildings shall be set in the list as real estate. So classic one shows up here from my world previously as a real estate attorney. There are a number of projects around the state that are built on leased land. So a landowner doesn't want to sell the property, but is willing to lease it long-term to someone. When I say long-term, a long-term lease for constructing a building is probably going to run somewhere between 40 and 99 years. And the lease, typically a very long, complex document, says landlord gets rent, tenant can build a building on the land, tenant owns the building on the land until the lease terminates, at which time the building reverts to the landlord. So if you have projects like that in your town, remember that the building on leased land is actually real estate. Don't let anybody tell you it's personal property. All right, some more things in chapter 123, section 3659. Talks about municipal lands located outside the bounds of the municipality owning the lands. Section 3701 talks about the computation of pilot payments. If you have state buildings in your municipality, then the state is paying you a payment in lieu of taxes or pilot payment. And that section tells you how those taxes are computed. It involves a very long process PVR undertakes. And if you think you're not getting enough money, well, take that up with the state. If you have lands owned by the Agency of Natural Resources in your towns, A&R gets an allocation from the legislature to pass along to you to offset the fact that half of your town isn't taxable and not fair to the rest of the residents in the town to impose on them the obligation. So A&R kicks in some money to meet your budget. Chapter 125, I did capture this particular page that talks about exemptions. We will talk about a few of these sections tomorrow in the first session. Specifically, we'll talk some about 3802 and then 3832. Knowing something about those might help you with a couple of the questions I'm going to ask tomorrow. All right, sections 4000, and again, I'm still in Title 32. Sections 4001 to 4088 deals with inventories. 4111 is the abstract of the individual lists. This is the statute that talks about how you create your abstract. 4112 and 4116 talk about correcting a defective list. 4151 talks about the process of certifying your list and the oath that you attach. 4152 talks about contents of the grand list. Remember that for for exempt properties, you need to talk, your replacement, you either need to identify a replacement value or full listed value. 7, I threw in 7 here, not because it makes any sense by itself, but this is a great example. Let's say you are led to the idea that you need to know what's in 4152 sub 7. Well, this isn't terribly helpful, but it specifically says that if you are using the provisions of 3607A, 3832 1, 6, and 7, and these sections, okay, then what you have to do is the value that reflects the taxes to be paid on such property, the full listed value absent such appraisal, the statutory authority for granting the appraisal, and the year in which the appraisal became effective and the year in which it ends. I believe those are your voted on exemptions. But you can't just count on this. You got to go back and look at each one of these sections and see what they refer to. So tomorrow we can look at 38, 32, 1, 6, and 7. So when you see a section that refers to other sections, be sure you go look at all the sections. 4154A is a favorite of mine. I was actually on the South Burlington City Council for a few years. The listers have an obligation to report to their select board the percentage of acreage within the municipality owned or controlled by A&R. I suspect that's so your select board can check and see if they're getting their A&R payments and if they're reasonable in amount. The 4155 to 4157 is the certification we just looked at. 4158 talks about what happens when the grand list is lost or destroyed. That must be something that raises fear in your hearts. 4162 is correcting the omissions from a grand list. That tells you the process. I will tell you one last story that goes along with that. As I said, I was on the city council in South Burlington. The first year I was on the council, there were 2 new councilors who were elected at the same time I was. And the city assessor showed up in the last meeting before December 31st. He had a list of about 25 corrections to the grand list. Most of them involved addresses, names, classifications, other stuff that was really nothing big. And one of the counselors just went off on the poor guy because how could he do his job so poorly that the city council had to take their time to correct his work. Honestly, this counselor went on for like 3 or 4 minutes until somebody turned around and said, "This is a fairly standard practice. I move that we approve the changes." And all of us immediately put up our hand, cutting off the discussion. But so if your select board decides to take you to task for that, don't feel bad. You're not the only one. All right. So I see we only had one question pop up, and it was a great question. I love this question. Where do you find the section symbol on the keyboard? It isn't on the keyboard. If you use Windows, you're going to go to the menu choice in Word that lets you insert. You're going to go to the button that says Insert Symbol. And then if you are me or like me, you are going to spend a frustrating 3 to 5 minutes scrolling through a list of 1,000 symbols looking for this one symbol. It's somewhere in that collection of symbols in the boxes, and you can click on it and it will insert the symbol. And then if you're writing something that needs the section symbol again, you copy and paste it for everything else in that document. And I'm sorry, that's the best I can give you. Years ago in WordPerfect, which I thought was the most perfect word processor in the world, you could hold down the Alt key and type 0147, and it would have inserted the section symbol for you. Word says something inappropriate to you if you try to do that. So it's under the insert and symbol. So Jen, how about we take a couple of minutes for a break? I think we're all still here.
Yes, go ahead whenever you're ready.
Okay, all right. there is one potential problem, which is my Wi-Fi periodically simply drops out for no reason, and I'll sit here and talk to myself for a few minutes before I realize I'm not connected anymore. So if I disappear, that might be what happened. All right, so starting with session 2, we're going to talk about common law, or what's known as the law made by the courts. And I'm assuming that we don't have any new folks here, but just remember, I'm not your lawyer. I'm not telling you the answers to questions here. I'm telling you how to begin to look for the answers to questions. All right, let's start with this. As you all know, Vermont was formed out of the original, depending on where you were, either the New Hampshire colony or the York colony, settled by the English, late 1600s through the 1700s, until Vermont declared our independence from everybody in the world, and then eventually joined the United States. But most of the people who settled here probably came from an English world background. Now, I know that there were French, Dutch, and other folks who came who would actually have had slightly different legal systems than the English had. But because most of the people who settled here in Vermont were from English descent, they simply adopted the English common law. English common law has been growing starting in the 1200s and continues to grow today. So starting in 1789, the Vermont adopted the English common law as it was then. I think this is great. The phrase that they used was well-developed principles are adopted. Now, of course, the well-developed principles were up totally for debate. Every time the Supreme Court heard a case, we debated whether or not the English common law was the right thing to use, but it was a good place to start, and it gave us lots of words to use. And then essentially the common law grows over time, and it grows through the process of resolving disputes between parties. So the idea is that there is a key principle. This is the one that's hard for people studying the law, whether you're studying in law school or studying through the Law Office Study Program, which is in effect here in Vermont, is to understand the key legal principle that underlies all of common law, which is, not in English, stare decisis, that which has been decided. And the best explanation is that once a principle of law is established, whether it's established by statute or through case law, that principle is applied in all future cases. And then you notice that I tried every possible means of emphasizing this except color, with similar facts. So it is the true skill set of a person who practices law, whether they're a lawyer or whether they work in government or wherever they use the skill set that they have, is to be able to quickly compare their circumstances to the circumstances in the cases that have been decided on the principle that they are trying to apply. So the way this works is two or more people get into a dispute. They go to court. There's a process to tell the judge what the facts are. And then the judge, sometimes with the help of law clerks, not so much in Vermont, but in the federal system and in many states, the courts employ lawyers to help the judges find the law. The judge researches the law and says, well, this case isn't the same as my case. I'm not, okay, I get the general principle, but that doesn't help. And, oh, this case is really close to my case. There's a couple of things that are a little bit different, but are they different enough to adopt a new principle? No, I think this is pretty close. We're going to go with this, and I'm going to decide the case that's before me based on this other case that I found, where the facts are pretty much the same. And so the principle grows in strength because now it's not one case that says this is what you ought to do in this circumstance. There are now two cases. And there's nothing that a lawyer likes better than finding a whole bunch of cases on a range of facts that all say, this is the reason we're going to decide this case this way. But of course, it only works as long as the judges follow the rule, which is, these are the facts. This is the law that applies in these facts. I don't like the outcome of this case. I don't think the person who's going to win because I follow this set of principles applied to this particular set of facts should win. And I think they shouldn't win. So the question comes down to, can the judge find enough facts to, and this is the word we use, distinguish the current dispute from all the prior ones? Now, sometimes it's pretty clear. In 1783, there were not many cases where somebody copied your artwork and put it on Facebook. So, however, there probably were cases where someone copied your artwork, and actually copyright is a very old principle. But should it apply to Facebook, where everybody can just cut and paste? Well, some of the judges said yes, some of the judges said no. The circumstances come down to the better rule is yes. You shouldn't be able to copy someone else's work and put it on Facebook. I'll accept, but unless you fit one of the exemptions to copyright law, and then you can. But those exemptions are pretty well laid out too. And so the judge should follow the rule, but maybe there's some reason that this person did something a little bit different. They copied the artwork, but they added something to it that makes it inappropriate, and you don't want that to be allowed. Okay, well, that fact is a little bit different, and so maybe the rule should be different. Maybe you shouldn't be allowed to copy that. Or maybe they, instead of making the product worse, made it better. They took out some of the elements that were inappropriate. And so the judge really wants to say, I know the law says you can't copy, but I think when you make the artwork better, you ought to be able to publish that artwork. So you changed it. Well, there are some rules about how much of a change constitutes change. So in this case, the judge doesn't like the outcome with the general rule, finds some facts that they can apply, and says, nope, slightly different rule applies. If you take the piece of artwork, take out inappropriate elements, and make it better for the general public to see, you can publish that. Now, does that follow the general rule? Well, yeah, because I said the facts changed. Question is, how big a change in those facts do you need to find in order to be able to adopt a different rule? Different judges have different levels of willingness to pass a precedent. Precedent is the word we use for prior cases, and follow a new rule. So that's what makes the development of the common law so much fun, and the reason that you have people like me to keep up with that. All right, so common law depends on a court system. And I don't know how many of you have had experience with the court system. I hope not many of you have had experience with the criminal court system. In fact, I hope most of you haven't had experience with the civil court system either. But you may very well have been involved in either probate or possibly family law stuff. But disputes in Vermont typically start in a court system, with the exception that some stuff starts in an administrative forum or a quasi-judicial proceeding. Could I be talking about tax appeals? Well, I could, because they start in an administrative proceeding. They start with you because you do the grievances. They continue in an administrative role or in a quasi-judicial role at Board of Civil Authority. Then they may go back to an administrative proceeding if you appeal to PVR, or they may jump over to the court system if the appeal goes to the court system. So in Vermont, for those of you who are not familiar with the Vermont court system, we have one level of trial courts, and it has different divisions. And that is the criminal division, which handles the prosecution of crimes against by the state of Vermont. That's all they do. If you break the law and you are arrested and prosecuted, you are going to be operating in the criminal division. If you have a dispute with someone else that does not involve breaking a state law and prosecution, you are likely going to end up in the civil division. And that's where most disputes end up. Family division deals with stuff like divorce, property settlements, and that kind of thing. Probate division takes care of the assets of deceased persons. So when your grandmother passes away and her will says that you get the all her jewelry, then the probate division is the element, is the division in the court system that will look at her will, decide if will is valid, and if it is, the court system will decree that you get the jewelry. The last one is kind of a specialized division. It's the newest division in the court system, which is the environmental division. And that is where appeals from zoning cases and state permit cases and some enforcement cases goes. And the two judges there are primarily specialists in regulatory, so permit processes and the regulatory process around permit processes. So you pick the division you go into based on sort of the nature of your dispute. It's possible you try to go to the wrong division. You try to take a dispute that involves a will to superior to the civil division in the superior court, and they will tell you you're in the wrong place. This has to go to probate court first. Now, it happens that if you appeal a probate court ruling, you'll go to the civil division first, and then Supreme Court. And the way a court case often goes is this. There is some kind of an initial set of pleadings. Typically, it's called a complaint and an answer. And in the complaint, the party who claims to have been injured, and injury isn't just I hit them with my car. The party is injured if I don't perform under a contract, or if I say something bad about them. That might be defamation. If I wrote it, it might be libel. And so the first thing the plaintiff has to do, the plaintiff is the person who claims to be injured. They have to create a story in a sort of formal setting that explains what happened to them, who did it, why they should be in court, and what they want. And they have to now take that document and go to the people that they claim did them the injury and present it to them in a mostly formal process. And so depending on how it happens, if you got two businesses arguing over contract terms, plaintiff's lawyer is going to call a defendant's lawyer and say, will you accept service? And most of us would probably say yes, unless our client flat out said, you're never to accept service on my behalf. And then you go, sorry, you'll have to serve. But if you don't, if you can't contact a lawyer, or you contact them and you say, will you accept service? They don't know what you're talking about, so they say no. You give the document to a deputy sheriff who charges you $125, $150, and goes and delivers it to the person. And if you watch TV and you watch court TV, you'll see that somebody shows up and says, here, sign this, and you should always say why. And they're going to hand you something and say you've been served. Civil process servers are technically legal in Vermont, but they're not widely used, I don't believe. I think most people use the deputy sheriff to make service on people. All right, well, now I've been served. I said something bad about you in the process that you used to assess my house. Not only did I appeal the assessment, but I went to the local paper and said the listers in South Burlington, and there are none, totally discriminated against me because they don't like the color of my house, and they raise the value illegally, and I say all kinds of bad things about you. So you want to sue me. So you lay out the story of what happened. You serve me with the documents. So now I have to make a choice. Do I admit that I did all of that? Probably not. So I get to now tell my side of this story, except in a much abbreviated concept. So I'm going to take your complaint, which is typically laid out in a series of numbered paragraphs. And in that, I'm going to send you back a list of answers. And the first statement in most complaints is the defendant name is James Knapp, and he lives in South Burlington. That happens to be true. I am technically required by law to admit that that is true. So my first response to the first statement in your story is admit it. From there on, I can deny that I ever said anything bad about you. I can deny I told the city manager that you did a terrible job of listing my property. I can deny I ever said that. I can do things even so currently difficult to comprehend as say, even if I did say the listers did a bad job of listing my house, it was a joke. I didn't mean it. It wasn't meant to be the truth. So maybe I did say it, but I didn't mean it. And so I go through your whole story and agree with your statements, disagree with your statements. And maybe when I get to the end, I say, and because you listed my house so high, which you didn't do legally, I couldn't sell it. That's not going to be much of a case, but I guess I can say that. And that would be a counterclaim. I have some reason to think you injured me. And so then I would tell my story about the counterclaim and the injury that you did to me. And now the court gets both of these documents, and the court has no idea what the truth is. And the court has no idea about anything. And so the process invites us to undertake two processes. They typically run in parallel. They are typically expensive, and they typically sort of relate to each other. So you might point out that my story doesn't constitute an injury. So you would file a motion to dismiss with the court. And you would tell the court, that story's pathetic. Not only is it not true, but even if it was true, he can't get anything from us because of it. Now, the court probably look at it and say, well, there's not enough here to know for sure. We're gonna deny the motion to dismiss. But if it is so clear to the court that my story, my counter story to yours, was so wrong or not supported by any law, or as we like to say, not supported by any reasonable or rational extension of an existing law, the court can say, you're right. Knapp's claim is dismissed. We're not going to deal with it anymore. It's gone. So that's motions. And there are all kinds of motions that get made. There are motions to dismiss. There are motions to add more people to the case because everybody who was injured isn't in the case. There are, the ultimate motion is typically a motion for summary judgment. And there, the two parties essentially have gone back and forth in the next process I'm going to discuss, which is discovery. And they will have settled on a set of facts. And in the unusual circumstance where both parties agree on the principal facts of the case, the two parties can go to court and say, Judge, we've essentially agreed on what the facts are, and then each of us is going to make an argument why the law is on our side. You're going to argue that having said bad things, I caused you injury because other people in town started to think badly of you because you did a bad job. I'm going to argue that maybe I said all that stuff, but I didn't say it to injure them. I just said it as a joke. And jokes aren't defamation, technically, because I didn't intend to injure you. Maybe I did, and that's one of those things that the judge should now say, neither of you wins, we're going to trial. But the summary judgment allows you to argue the law to a judge based on a substantially agreed upon set of facts. The other piece that takes up most of the cost of litigation, and frankly, one of the reasons to look seriously at whether litigation is the right solution to your problem, is the so-called discovery process. 50, 75 years ago, well, yeah, 50 years ago, give or take, there wasn't much in the way of discovery. This is a process by which each side gets to ask the other side about their case. And 50 years ago, most trials were pretty much a nonviolent ambush. I don't tell you who my witnesses are. I don't tell you what I'm going to rely on for facts. You don't tell me who your witnesses are. You don't tell me what you got for facts. And we show up in court one day, and the better set of facts wins, typically. Starting about 50 years ago, the courts realized that this was a stupid way to resolve disputes. There was a broad movement across the country to say, look, we want you to dig into the other side's case and really figure out what's going on. Because maybe this whole dispute goes away because they can't prove their case. They don't have the right evidence. Even if they have evidence, it isn't good enough to win. And so you do stuff like depositions. And that's where my lawyer gets you sitting in a chair on the opposite side and gets to ask you questions about the case. When did Knapp say this bad stuff about you? Where did he say this bad stuff about you? Did he say the bad stuff about you holding up a sign that said this is a joke? Did he tell a reporter that you were inept, but also point out that his house was probably worth what you said it was worth? So the lawyer gets to ask these questions. There's also a process by which the lawyer can write down questions. Those are called interrogatories, and send you the questions, and you are obligated to answer them. And those interrogatories can be miserable to deal with. They can be very expensive. Depositions are no fun either. I've been deposed a few times. I've done a few depositions. And to be honest with you, I am not and never have been a litigator. I've always been a transactional attorney. My brain doesn't work in the litigation context. And being deposed was no fun. I didn't particularly like doing the depositions, although I was able to discover a whole bunch of interesting stuff that the other side didn't do particularly well. And I was able to force them into a settlement that was pretty good for my client. In the one case in 43 years that I actually had to try. Not to a court. We settled out of court. But one case in 43 years where I actually had to do all of this stuff. And so the discovery process is long because it's a back and forth process. Depositions are expensive because the lawyer doesn't just walk into a deposition and ask random questions. The lawyer has laid out their whole case, spent hours and hours and hours, at hundreds of dollars per hour, setting up the deposition to come to a specific result where hopefully you get the other side to admit that either their case was really bad or admit that they really did what they said they were supposed that you claim that they did. So and discovery can go on for years. And starting in about the last 10 or 15 years, discovery involves stuff like your emails, your texts, your social media presence. You've all heard about the wonderful case where A sues B because A was injured in a car accident and they are so injured that they can't enjoy life anymore. All they can do is sit in their house. They can't work. They need millions and millions of dollars to compensate them for the injury. And then they go and post pictures of them water skiing on their Facebook page after the injury supposedly occurred. All of that can be discovered. Lawyers are good at finding stuff like that. And so the discovery process often either narrows the case down to a really small set of facts that you simply can't agree on, and in many cases works to negotiate a settlement to make the whole case go away so it never goes to trial. But let's say you're in that circumstance where you've got facts that nobody agrees on. And so you go to trial. And in the trial, you may be talking to a jury of 6, 9, or 12 people who are picked to listen to the dispute and decide what the facts are, or you may be presenting the case to a judge. The jury or the judge is going to come to a decision. Somebody wins, somebody loses. Typically, both parties lose because neither one gets what they really want. And then we start the motion practice over again. The party that lost can argue to the court, there was no evidence to support the outcome the jury came up with. You applied the wrong law to the case, all kinds of post-trial motions. And so this procedural process goes on and forever and ever. And like I said, there's always a decision, or almost always a decision, unless the parties settle somewhere through in the middle of the case. It is not unheard of for a judge to call the lawyers into chambers. That's where the judge's office is, or what it's called, and say, okay, Jim, you're close to the end of your case. I don't see it. I don't see where you're going to prove all 6 elements of this particular claim. Maybe you've got some more stuff that I haven't seen yet, kind of on the borderline. Turns around to the other person and says, okay, other lawyer, he's got some interesting stuff. I don't know if it's enough to get through and win what he wants, but if he does, you're going to lose big. So maybe the two of you ought to go out in the hallway and figure out a good resolution to this case that doesn't involve a decision by me or the jury. That actually happens a lot more than you think. But if we get to the point where somebody has to make a decision, then in a bench trial, The judge is going to make the decision on the facts and on the law. In a jury case, the jury will determine what the facts are and will apply the law the judge tells them to the facts to come to a decision. So the jury doesn't have to know the law. They have to listen to the evidence, and then they have to follow the rules the judge gives them. And so let's say in our example, you win and I lose. The jury finds that my statements were defamatory, that you were injured, that by losing status in the community, you were unfortunately not reelected as a lister, and you were not able to collect your $25 a day for the work that you did, maybe $25 an hour. I don't know what the current pay scales are. And as a result, I should pay you $20,000, which is what you lost by not being able to be a lister anymore, at least for a couple of years until people forget and they reelect you. And because what I did really wasn't very nice, there might be some punitive damages in there. And so maybe that represents $10,000, $15,000 of the whole thing. I don't like that decision. I still think I was right, as long as I made it clear that I was telling a joke and not really trying to defame you. I shouldn't have to pay you anything. So I'm going to exercise my right, and I'm going to appeal to the Vermont Supreme Court. Now, in Vermont, we only have the one level. If you lose at the trial court level, you go to the Supreme Court. In other states, if you lose at the trial court level, you go to an intermediate appellate court that deals with cases that are not big public policy cases. And so the intermediate court is going to rule on a case like ours. On the other hand, if you are bringing a case that says the entire school tax process in Vermont is unconstitutional, that's going to go all the way to the highest court in Vermont or in New York or in whatever state, because that's a major public policy circumstance. No intermediate appellate court's decision is likely to resolve that particular case. So how do you get to the Supreme Court? Well, the first thing you need to understand is that the Supreme Court doesn't do a trial. They don't hear new facts. They take the facts that were discovered at the trial court level, and they determine whether the law that was applied was right or wrong. So, switching cases, I've already lost. The Supreme Court's going to uphold your decision. You're going to win. Good luck getting the 20 grand out of me, but you're going to win. But let's say we're at one of these major public policy cases. The Supreme Court is going to look at the facts that were developed. Each party is going to first tell the court what the general issues are in their notice of appeal. You have to tell the technically you tell the trial court that you're appealing their decision. And the trial court tells the Supreme Court, hey, these guys say we did a bad job, got a new case coming your way. And the trial court sends all the evidence and everything up to the Supreme Court. And then the parties, lawyers, and it's almost always lawyers involved at the Supreme Court, even if there were not lawyers necessarily involved at the trial court level. There are almost always lawyers at the Supreme Court, and each side gets to write a brief. It is typically about a 25-page argument where, on behalf of your client, you take the facts that the trial court had and you tell the court how the law should have been applied. So in one case, you are essentially saying the trial court did a great job. They found the exact law. They applied it absolutely correctly to all of the facts, and their decision should be upheld. The other side, on the other hand, is saying, while we have to accept that these are the facts, first, the trial court threw out some evidence that they should have heard, which would have changed the facts. Second, the findings that the trial court made are incomplete. They didn't include all of the facts, so you need to get more facts from them before you can make a decision. And third, the trial court just got the law completely wrong. Yeah, there might be some cases that say this, but look, our facts are different from those cases, and those cases shouldn't control the outcome here. You, Supreme Court, should announce a variation on the general rule that means we win. And this, again, long process, expensive, requires lots and lots of research, requires lots and lots of time. And so if you're going to appeal to the Supreme Court, be sure your case is worth it. But if it is, then that's the process you're going to follow. The Supreme Court has a choice. They can give you time to argue. They don't have to give you time to argue. They almost always give you time to argue a case if you request it. You can, in fact, ask the Supreme Court to decide simply on the briefs. If truly the only dispute is what law the court applied, you may very well say, look, we all agree what the facts are. Let's just get the Supreme Court to tell us what the correct law is. And so maybe each party gets 15 minutes to argue before the Supreme Court, but that is something of a misnomer because every Supreme Court case I have ever observed starts this way. The party who's filing the appeal stands up. The lawyer says, may it please the court, my name is James Knapp. I'm here to represent the appellant. And the justices start asking questions. They've already read your briefs. They mostly know what the case is about. Each of them has something in your brief or the other party's brief that sticks in their mind. And they don't care what you have to say. They want you to answer the question. So often, most of your time in the argument is taken up either responding to justices' questions, or if they ask a question, trying to craft, twist, pull, mold, adjust your argument, respond to whatever the concern they've expressed is. It is a fascinating process to watch good lawyers argue before the Supreme Court. Ultimately, just like in the trial system, the Supreme Court is going to issue a decision. They issue two kinds of decisions. One decision is published because it announces an important principle of law. It's an important dispute. They want people to know how the dispute was resolved. There are also unpublished decisions. Typically, the Vermont Supreme Court has 5 justices, but sometimes only 3 of them hear the case. It's called the rocket docket. And if 3 justices hear the case, you can't use that case in the future as precedent. It doesn't form part of the process of stare decisis, but you get a quick decision. And so the unpublished decisions can tell you what the current Supreme Court thinks about your issue, but you can't technically cite one of those cases as binding authority in another court or in another case. All right, so now that you know how we get there, what do you do with this information? Well, there are quite a few cases out there that deal with tax assessment, setting values, procedures in tax assessment, appeal, listers, and all kinds of things. So a lot of this is actually going to be somewhat relevant to you. But you got to find it. And now I'm going to tell you that unlike statutes, which is relatively easy, finding cases without help can be a bit of a challenge. So you can go to the www.vermontjudiciary.org. Links in the materials. You can eventually find your way through the process to get to the Supreme Court site, or you can just type out or click on that whole link in vermontjudiciary.org/supreme-court, and you will get to the published reports of the Vermont Supreme Court for the last 13, 14 years. I think they started publishing them in around 2010. Before that, they did publish them, but not on the World Wide Web. You can go all the way back into the early 90s when the Supreme Court had this wonderful website that was referred to as a gopher, literally Gopher, and it was where you go for information. And if you were lucky enough to have the login information, the court would let you access a bundle of cases, and access is a strange word because you kind of had to know how to find it to begin with, that they had set aside for the public to access just to see how it worked. Eventually, they did like everybody else did. They threw it onto the World Wide Web. And frankly, there are major publishers of legal information that collect information from the court's website every day and publish it through their own portals. So you've probably heard of Westlaw. I mentioned LexisNexis when we talked about the statutes. Well, LexisNexis is also a big publisher of court decisions throughout the United States. It's not just Vermont decisions, obviously, but all the federal courts, all the levels of the federal courts, all the state courts, all the levels of the state courts in Vermont, in Westlaw, LexisNexis, and several others. You can actually access trial court decisions too. If the judge writes an opinion, which they often do in summary judgment cases or in bench trials, the only way they can publish the decision is to write a decision because there's no jury to make the decision. And those cases are slowly becoming available too, which are a wonderful resource because, quite frankly, the Vermont Supreme Court, for the 200 plus years to almost 250 years it's been in existence, hasn't really decided a lot of cases. For example, the cases are published in the brown books to distinguish them from the green books. And each brown book is about 1.5 inches, 2 inches wide, covers 1 year. Sometimes a little bit more than a year, sometimes a little bit less than a year, depends on how busy the court is and how long the opinions are. And so in Vermont, the Supreme Court probably decides 40, 50, maybe 60 cases in a year. Now you got to know there's a lot more disputes than that. So a lot of cases never reach the Supreme Court. But if you were to go, throughout all of Vermont's history, there are probably 210, 220 volumes of reports of the cases reported out of the Supreme Court. Over in New York, there are a fourth series of case books. There's 1,000 books in each series. And those are the cases that came out of the New York Supreme Court, or which they don't actually call it Supreme Court, they call it the New York Court of Appeals. But they have a huge volume of cases. And Vermont has a relatively small volume of cases. So finding them is not that hard, except there aren't particularly great resources unless you pay for a subscription to LexisNexis or Westlaw or one of the other research services. And they are not inexpensive. You may pay several $100s a month to access their materials. It doesn't really work for your average person, even your average municipal official. Good news is you have lawyers who work for you, who do have access to Lexis, Westlaw, Fastcase, one of the other research services, and they can look up stuff for you. But if you're really interested and you want to do some research in Vermont, The place to go is not the Vermont Judiciary website. Their search engine is the most pathetic piece of software code in the world. Where you want to go is a place called Google Scholar. And in Google Scholar, this is the Supreme Court website. You can look at the published opinions. You can search decisions. Don't bother. The search engine sort of forces you to put in a date. It forces you to select a court, and then it wants a document type. It will give you a keyword search box. I didn't bother to go through all of it because, interestingly, you can't take pictures of each step. If you click on these boxes but don't go to the last step, it won't give you the search box. Then it can't show you the boxes. So it doesn't work particularly well. I've never found, I don't believe I've ever found a case using this search engine. But on the other hand, this works really good. Now you'll notice this is not google.com. This is scholar.google.com. And this is where you go to do research, academic research. They have lots, they have the most amazing collection of stuff, 99.9% of which you don't care about. But if you are curious and fascinated by the oddities, which you may guess is kind of describes me for better or for worse, this is a great place to go and type in random stuff and see what you get. What you really want to do is click on this button that says case law. You'll get another page that will let you select Vermont courts. And then after you do that the first time, or the first couple of times, you'll end up with Vermont courts as a button on the front page. And then in here, you type your query. And this actually works pretty well. I find a lot of stuff here. Well, often if you were to call and ask me how to get started on some research, I would tell you what I put in that box. And then I might print out a list of some of the cases that I got so you can take a look at them. And so that becomes sort of a fascinating process. You can literally type anything in this box: case name, topic, subject, anything that you can think of. And it's just like Google. So be careful. You always want to type Vermont first, because otherwise you may get 500 cases from other states, which don't do you any good. And so I gave you an example. This will be fun sometime when you have a minute that you're not doing something that you have to be doing. Take the name of one of the cases that I sent you. I gave you Rasmussen here. Type in Vermont into the Google search engine, the Google Scholar search engine, and see what you get. Now, the other place that, of course, you're going to find stuff is sometimes third-party materials like the league's materials, maybe the lister's handbook, maybe some of the materials you get from other seminars and national seminars will have a case name in it. And so you need to know what the citation means. Now, remember, I told you that last session in law school, one of the things you learn is where periods, commas, colons, paragraphs, semicolons, and all of that good stuff goes. Well, here was my best attempt to remember. I probably would have gotten a C+ on this, I'm sure, in legal writing, but I picked a case, the American Museum of Fly Fishing, Inc. versus the town of Manchester, because we're going to talk about that case tomorrow at some length. And this is what this citation means. Obviously, these are the parties that were involved in the case. Sometimes in here, you'll see the word et al. That means that on one side of the case or the other, there were a whole bunch of other people. Et al means everybody in Latin. That's not the actual Latin phrase. It's a shortened version of it. It's an acronym for it. But the idea is these were the two cases that these were the two parties that most people would know in that circumstance. The volume, So 557A2D 900 tells you that you would go to volume 557 of the Atlantic Reports second. What the heck is that? There is a publishing company by the name of West Publishing. You've probably heard of them. West Publishing has for, well, technically not forever, but for a very long time, has had the right to publish case decisions from all of the courts in all of the courts in all of the states, and all of the United States, along with all of the federal courts and a whole bunch of other stuff that you've never ever heard of and won't care about. And they do it by breaking up the country into regions. So there's the Atlantic reports where Vermont happens to be. There are the Pacific reports. There are the Southeast reports. There are the Southwest reports. There's a whole bunch of other ones. And so as you can imagine, these are a lot of books. Now, typically West is publishing digitally and most people are using digital services, but I think they are still publishing the books. So you may be able to go places and find books, particularly the older books. Westlaw, Lexis, Fastcase have done a pretty good job of digging up the old decisions, running them through an optical character recognition system, and publishing the text digitally. So like I said, almost nobody goes and looks at the old books. I do sometimes because I like reading the books. It's just the way I work. And sometimes I have to read the cases printed because for whatever reason, reading it on a screen can't follow the case. And sometimes I have to draw arrows and diagrams and all sorts of stuff to make it work. So the 557A2D is the Atlantic 2nd, page 900. You'll find the case there. There is a parallel citation to the Vermont court reports, which are not published by West. They're published by Equity or LexisNexis. And the fly fishing case is in volume 151 of the Vermont reports, the so-called brown books at page 103. The Vermont tells you it was decided by a Vermont court, and the 1989 tells you the year that it was decided, because it may be relevant, because the law on exemptions before the fly fishing case was different than the law on exemptions after the fly fishing case. So if your dispute took place before 1989, you might need to know what the law was before that. All right, so I just noticed that there was a question in the chat, and it says, what if the delinquent tax is still outstanding and the probate court issues the final decree of distribution on that property, even though the back taxes have not been paid? This is not legal advice. Bear that in mind. The general rule is that the unpaid delinquent tax attaches to the land, not the person. I may owe the taxes, but ultimately my house owes the taxes. Proceedings can be against the individual, but the most typical collection process is to proceed strictly against the land in what's called an in rem action. And so I believe, but I don't know this to be true, that the town should have filed a notice of claim in the probate court. So the town's interest should have been adjusted by the probate court. Certainly the executor should have known that there were delinquent taxes, because the executor is bound by law to investigate the assets of the deceased and the claims against the deceased's estate. So now we got two people who should have been paying attention to that, the town and the executor. Certainly the lawyer for the executor should have been paying attention to that. Now we got three people who should have been paying attention. I believe the taxes would follow the land into the hands of whoever got property, whether it was decreed, sold, whatever, should have been picked up in a title search if the taxes were not paid at the time the property was sold by the executor. But there is a statute of limitations for the collection of those taxes. So if the town lets the period of time that the statute of limitations runs, those taxes become uncollectible. But until they're collected, property taxes in Vermont are what we call a super lien. They take priority over every other claim against the property, with potentially some exceptions. Where you run into trouble is when there's a bankruptcy court involved. That turns into a mess. All right, so we found the court cases. Let's say we found Rasmussen versus the town of Fairhaven, a favorite case of mine for a reason that you'll hear a hint on when I get to that case decision. What's the first thing you do? Read the decision all the way through, try to understand the story. Cases are always about a story. They may be hyper-technical cases involving the valuation of the dam, the hydro dams, and related stuff on the Connecticut River involving hundreds of millions of dollars. But there's a story. What does the dam do? How much money does it produce? What's its condition? All kinds of things. Read the whole case all the way through. And I gave you some sample cases to take a look at when you have a few minutes. The idea is, first, look for the story. Second, make a list of the facts that the court thought were critical to making their decision. Sometimes they'll put most of those right at the beginning of the decision, but not always. Sometimes they kind of string you along by throwing out a couple of facts at the beginning, and then a little ways into the opinion, they'll throw out something else that's critical, and then a little bit farther, they'll throw out something more that's critical. So that's why you read the whole thing first, then you make your list of key facts, then look for the law that the court says, here's the general principle. Then you look to see whether the court is leaning towards following the general principle or leaning to say, you know, these facts aren't like the facts that develop the general principle. We're going to do something different. And then the last step is check and be sure that the whole court agreed. Remember, I said Vermont has 5 justices, the Supreme Court, United States Supreme Court has 9. Sometimes the decision is simply the decision of the majority of the justices. In Vermont, it's not unheard of to have a 3-2 decision. So 3 justices agree on one result. The other 2 justices don't agree. They dissent. They have a reason why the court should not have decided the case the way it did. The United States Supreme Court, we used to see a fair number of unanimous decisions. Now we tend to see 6-3s, 5-4s, with sometimes all of the dissenting justices reading their own, writing their own dissent. All right. Oops. Probably should be going through the materials, not backwards. All right. So you read the decision. What happened? There are 3 decisions that the Supreme Court can make. Remember, they're only looking at the law. They are not trying to retry the facts. You can't bring up new facts in the Supreme Court. You can only use the facts that were presented to the trial court. So the Supreme Court can uphold the lower court's decision. Yep, they were right. Did a great job of figuring out what the relevant facts were based on the evidence. They got the law right. Maybe the jury made the right decision, or the judge made the right decision. The judge made the right decision when he told it, or she told the jury what the law was. Great outcome all around. Lower court decision stands. Next case. Sometimes the Supreme Court looks at the circumstances and says, oh, close, no cigar for this one. Maybe the trial court or the administrative hearing officer didn't get the law quite right. Maybe the lower court thought there were some important facts that really weren't the facts the Supreme Court thought were important. And if they applied the existing law to the facts that the Supreme Court thought were important, a different outcome would come out. Oh, send it back down. That's called a remand. And there, the trial court or the administrative hearing officer or the administrative body gets the decision back, and they have to do it again. So maybe there's a new trial. Maybe there's just a new decision. Maybe all the facts were there. Sometimes on a remand, what the Supreme Court is saying is, and this often happens, unfortunately, in property tax appeals, okay, we kind of get it, but there are not enough facts here to really figure out what happened. So we want you to go back and either hold another hearing, or, as is often the case, we want you to write a better decision. We need more facts. Give us more facts, we'll reconsider. So a case that goes back on remand often comes back to the Supreme Court, hopefully with either a better decision, new cases, new facts, a reapplication of the law. Sometimes, though, on remand, the trial court gets it so right that the parties say, yeah, fine, go with that decision. The third is, if you're a trial court judge, sort of the worst outcome you can get. A remand isn't great, but that just means that you came close, but not quite right. A reversal is the outright, the court said, no, you got it wrong. We're gonna write a whole new decision for you, and typically the other party wins. Oops. Yeah, so if you're a judge, you really don't want your decision remanded. Reversed. Remanded, you can kind of live with. All right, so I told you how to read a case. Now I'm going to tell you all the warnings that go along with that. Just because you found the case doesn't mean it's the only case. Doesn't mean it's the current case. The problem is that the court has the power to overrule itself. We will see, I think one of the cases, fly fishing. The Supreme Court essentially said, yeah, we know this used to be the law, but we don't think this really works in the modern world. So now we're going to give you a new principle when you deal with exempt properties. Oh, so if you were accustomed to doing your exemptions pre-fly fishing, you would be doing them wrong because the Supreme Court changed. If you didn't know about the fly fishing case and you kept doing them wrong, eventually the appeals will show up at the Supreme Court, and the Supreme Court will be happy to tell you that you aren't doing this correctly, you're not applying the correct law. So the other thing is, be careful. You may find a case that has not been officially overturned. It may be one of several cases, and the outcome in this case is good for you. And the facts are close enough to your facts so that you and your advisors think, well, this is pretty good. We can go with this. That case may not explain the law completely. There may be other nuances that the Supreme Court is going to look for that you didn't think of because you weren't aware that the whole body of case law around this specific principle would have told you that, oh, they also like to know not just A, B, C, and D, but we also need to tell them about J and K and maybe O in order to get the decision we want. And like I said, the Supreme Court can overrule itself. There are resources that will tell you if a case has been overruled. Sometimes the case is overruled on only one minor point. So you look quick. We used to call it shepherdizing because the publication, the books that we used to test whether cases were still good law or not, were called Shepherd's citations. Now it's all done electronically through digital resources. But if you look too quick at Shepherd's, you might not have noticed that the issue in the case that you were interested in was what they refer to as the third issue. So often the cases either have paragraph numbers or they have the case decisions are set out with various issues. And issues 1, 2, 5, 6, 7, 8, and 9 are still good law. 3 and 4 were overruled in a subsequent case. If you're not careful, you see that the case you're relying on was upheld, has never been overruled, but you didn't dive deep enough to find out that the principle out of that case that you're relying on was overruled. So I think the best I can tell you here is be careful out there. When you get down to the point where things are really going to make a difference, cost your town money, cost you money, come up with the wrong result, which is not what any of us want, be sure you get help from an experienced legal researcher. All right. So when I did this, when I was doing this in person, which I still miss because I always really like having all of you in the room and talking to you because my camera doesn't smile at me. The 3 stuffed animals that are watching me, so I have an audience to talk to, they don't smile much either. They're kind of stoic about this. I used to throw this one out, so I'm not going to ask you to respond because I'm running I missed my timing cues on a couple of these things. But this was a fascinating case involving listers, but it had nothing to do with the value of taxes. Real quick, listers from the town of Walden looking at property to conduct their appraisal. In walking the property that they're doing, they notice a new addition on the neighboring house, which belonged to the defendants, Cindy and Peter. The addition was not a part of their property appraisal in the past, so the listers decided to go check it out since they were there doing it anyway. Knocked on the door, no one was home. They walked around the perimeter of the house, measured the size of the addition, saw something, said something, and Cindy and Peter ended up in court. Now, we didn't talk about cases with the caption of State of Vermont versus Cindy and Peter, but that's a criminal court case. So I'll give you 20 seconds, 30 seconds. What did the listers see that they said something about that resulted in a prosecution? All right, let's see how quickly it takes one of you to type the answer. You got it. That's pretty good. That was exactly it. They saw an illegal marijuana growing operation. They reported it to a deputy sheriff who, based on the witness testimony of people who were legally on the property, because remember, by statute, the listers have the right to enter on the property. Whether you should be doing that without making appointments or not, it didn't used to make much of a difference. These days, I'd say be really careful about just showing up and walking on somebody's property because you never know what's going to happen in that circumstance. And interestingly, in this particular case, Cindy and Peter raised the question that this was an illegal search because the listers didn't have a warrant. We all know the cop shows say you can't go on the property without a warrant, right? There were certainly no exigent circumstances. I mean, listing is important, but it is not an emergency case where you enter on the property to save someone's life and notice that they passed out in a field of marijuana plants. And the court actually said no. The listers were not acting as agents of the police. They were there for a separate, legitimate legal reason that had nothing to do with this. The fact that they saw by accident your plants is not an illegal search. And Honestly, I don't remember. I believe they were convicted and they were appealing based on the illegal search. So sometimes being a lister doesn't mean setting the value on a piece of property. All right. We've still got enough time to do this. This is a combination of the earlier program and the later and this program. And this is an example of the development of the law through common law and statutes, and it relates specifically to the topic of covenant restricted housing. Now, I know that not every town in Vermont has covenant restricted housing, although I believe it's become a much more popular solution to the housing crisis than it used to be. But if you have not had experience with this, I will give you the 30-second definition. There are private or public or or nonprofit organizations that help people buy houses by various means. The one I'm most familiar with, because I'm from Chittenden County, is the Champlain Housing Trust model, where Champlain Housing Trust buys a residential property. They sell the house to someone who's going to live in it, just the house. They keep the land. They lease the homeowner the land for, I don't remember if it's 40 years or 99 years, for a relatively small amount of money, a few $100s a year. But what that means is they can sell the house for substantially less, because a building lot in most of Chittenden County is probably worth $125,000, $130,000. So all of a sudden we're shaving $130,000 off the price of the house and putting someone who needs help to live there. In exchange, the person who buys the house agrees to a covenant that runs forever with the land that says you can only sell this house to someone we approve of, and you don't get to keep the value increase. You get to keep a small piece of the increase in value, but Champlain Housing Trust gets to keep 75% of the amount by which the value of the house has gone up during your period of ownership. Because quite frankly, that's how we finance our operation, along with a lot of money from Vermont Housing Conservation Board and many other sources, but essentially capturing a significant part of the increase in value is how Champlain Housing Trust does what it does. All right, so we have a circumstance where there are two cases going up to the trial court level, and they were going up pretty much together on how to assess covenant restricted housing. There was a case in Essex and a case in Rockingham, I believe. In one town, the assessor said, look, the existence of this covenant doesn't actually affect the value of the house. To a third-party purchaser, to your classic, well-informed, arm's length, third-party purchaser, they don't care that the covenant exists. They're going to buy the house. The people who own the house care that the covenant exists because they're not going to get the full value of the increase in value. But between them and the housing trust or whoever owns the underlying fee, well, they're all going to get the full, they're going to get the full value. So we're going to look at each house. Now, in some circumstances, the way the covenant is constructed, because they're not all constructed the same way, may affect the value, and we'll take that into account. But we're not going to apply across the board a reduction in value simply because this is covenant restricted housing. In the other town, the listers or assessor, I don't remember which it was, said, nope, as soon as the covenant goes on the house, the value goes down. We're applying an automatic reduction in value. Automatic reduction in value. Okay. So these two cases go to the Supreme Court, and the Supreme Court says, hey, look, we got two cases that are based on almost exactly the same facts. They rely on the same statute. We can mush these two together, decide them the same way, because ultimately only one of these rules can survive. Either there is an impact on value, or there's an automatic impact on value, or you simply have to make a reasonable decision on whether there's an impact or not. And the court came down, reasonably well-written decision. I gave you a copy of it. You have to assess each property and the impact of the covenant. Do not apply an across-the-board reduction in value. If the covenant is very restrictive, it may affect the property. If it's one of the looser covenants, may not affect the value. This property may have so many factors that the existence of that covenant has nothing to do with it. This was not a unanimous decision. One of the justices on the Vermont Supreme Court dissented and said, no, if you read the statute, if you read all the words in the statute, if you read all the words in the statute and apply the principles of the statute, it is clear that the definition of fair market value has to accommodate some impact of that covenant, because I don't believe that the arm's length buyer, fully informed of the circumstances, is going to pay the full value in this circumstance, particularly if the new buyer is also going to be subject to the same covenant, which was a pretty good reading of that whole case. Now, I happen to have been the interim director at Property Valuation Review when this was happening, and I happen to have been in the legislature when court opinion came out on Friday. The court always releases all their published opinions on Friday, sometime around 10 o'clock. So if you got something hot going on and you really want to know, check the Supreme Court's website around 1 o'clock, which is when the published versions show up on the website. I don't believe the ink was dry on the court's decision when several legislators from Chittenden County on both the Senate and the House side showed up in Ways and Means in the middle of the session, not at the beginning of the session, but in the middle of the session, and introduced legislation to overrule Frank's decision. The ultimate determination appears in 32 VSA 3481 1C, and the legislature concluded that the covenant is by statute deemed to have an impact that reduces the value of the property by between 30 and 40%. The 30 to 40% was a negotiated outcome. The proponents who believed in the assess the property fairly based on the existence of all the factors said, well, we could live with 10%. We could probably go to 20% if we had to. The opponents said that the existence of the covenant reduces the value of the property by 70%. And there's no negotiating. It is 70. You take the value and you subtract 70%, and that's what the taxable value, or that's what the value, listed value of the property will be. The legislature couldn't quite stomach the 70%, so, and they couldn't live with the 10% because that didn't seem like much, so they settled on the 30 to 40%. So that's how a combination of court decisions and statutes interact with each other. Sometimes the legislature simply takes a perfectly good decision written by the Supreme Court and says, nope, you're wrong, we're going to change the law. And they do. All right. So in the last 10 minutes or so, actually, you know what? Since we were going to only keep you till 4 o'clock, I'll tell you what. A couple of these cases that I was going to talk about are going to show up in tomorrow afternoon's second program. So why don't we stop now, and I'll just slide these cases in the presentation of the second session tomorrow. Tomorrow, we're going to talk about exemptions, and then we're going to talk about appeals. So we'll see you all tomorrow.